As we wait for others to join, what I'm going to do is just give you a rundown of what we do at UCC Business Development and Consulting Institute. All right. So we are an operational unit within the University of the Commonwealth Caribbean and a member of the Jamaica Business Development Center, SMEs network, right? We at UCC aim to provide business advisory and consulting services to entrepreneurs and existing businesses. Our focus is on micro, small, and medium-sized enterprises. Our goal is to contribute to create impacts that support economic growth through fostering innovation and entrepreneurship. Our target clients are, and what we like to do is, first, let me let you know, yes, we are a part of UCC, but we also cater to not just students, but all entrepreneurs. So you have an idea of a business that you want to do. So what we would do is work with you to create this business idea, right? Build it out and just let you grow along the different levels, right? So tier 2, that is the early stage of business venture. That is where you would have already built out your idea. And what you're thinking of doing is maybe improving your marketing plan or creating a business plan to improve some product or whatnot. Tier 3 now, you may be seeking, say, and I would say more like you're looking to gain some financing, right? An example of that would be, we've had persons that are already established, they have a ton of clients, but they're having problems getting finance from a bank because the bank is saying to them, oh, you don't have a good enough business plan or whatever, right? So that's an example of a tier 3 client. They're growing, they're expanding, but they need some technical advice, or they need to work with a business development company in order to improve their chances of gaining financing, all right? So the services that we offer, we have business advisory and consulting services, training and development, research, mentorship and coaching, and we also have our back office services, which are Legal Bloom and Value Edge. Within the business advisory services, we provide evaluation of the business idea, the business model assessment, technical advice. We partner you up with lawyers and give you legal advice if need be. We also provide corporate governance and team building services. For our business consulting, like you said, if you need help creating a marketing plan, a business plan, financial plans, any type of plan, basically, we are there to help you. We also provide training. One second. We also provide training. These are the courses that we have coming up next year. We have ideation, pitching, business plan writing, costing and ROIs, e-commerce and website design, taxation and compliance, digital marketing, marketing tools, record keeping and bookkeeping, understanding financial statements, fundraising and partnership, as well as team building. So what we aim to do in this cohort was to go from the beginning right through to the ending of the process. Start with ideation, help you build out the idea, help you with the pitching or whatever. But how we do this is, if you want to do one course, you can do one course. If you want to do 3 courses, you can do 3 courses. We're not going to limit you. So we've had some bundles for you there. So that should help with the persons that would have done courses with us from before, that just want to do the little extra stuff, as well as the persons that are thinking of maybe improving their accounts, which is something that would have happened last year. Another thing we do is growth wheel. We have the growth wheel consultations, and these are free. And we will help you to build out the idea, your concept. We help you with your customer relations. But what we will be doing is working with you. So that means that you will have homework. So we would target all the different weak points within your business and then help to build it out with you. All right. We also have our mentorship program, speaking of homework. So that means that you'll be working with someone when we are working with you. All right. So, yes, Abraham Campbell. 1 second. Abraham?
Yes, hearing it. When we reach the compliance and taxes.
You mean taxation and compliance? You like to do that course?
Yeah.
That course is in March, and Colin Coley will be doing that. If you want to do one course, it's about 4,900, I believe, or 4,800. I'm not sure. All right.
So we can provide those information.
Yeah, of course. We'll do that. All right. All right, moving along. So you can work with the different business owners and managers to improve your different business programs, right? We also have the Legal Bloom services. Can you all see can you see, why am I seeing this?
We're seeing.
Okay, right. So we also have the back office services, which is the Legal Bloom service. We provide legal advice on business formalization processes. We can prepare contracts and legal documents. Yes, if you would rather go to a lawyer, you can do that. But we also know that persons are very frustrated when they have to do things like register their company or have to even fill out any forms. So we provide that service to you as well, right? And we also have the Value Edge product, which is we provide accounting services to you. We help you to maintain proper record keeping, right, of your books. We also provide you with financial statements as well. Okay. And the last part of what we do is the research effort, where we have, you can do marketing research, any data that you want, because we have access to students, and we also have our research department as well. So anything that you want to get, just some information or data to support something that you would like to promote, then we can help you with that. All right. So Cavelle is on.
I am a commercial and corporate practitioner. I do love litigation as well, but my focus has always been doing it right the first time. So I'm going to start from the full slideshow thing. Just give me a moment. But what I want to take you through today is just what I call the business checklist. And it will apply to various parts of your practice. So based on where you are and where you think you want to be. And then at the end, you can ask me questions, because there's never a perfect presentation, right? Great. So first, we're going to look at types of business formations. Then we're going to discuss briefly structuring your relationships between the persons that you have to work with, whether you want to have their services for technical skills or whether it's from the financial aspect of it, you want them to be a silent business partner. how to keep compliant, because when you go to seek financing, if you have to, the banks will want to know that you have been operating in a way that is compliant with all the business formalities. And why that is important is that if they're lending, they want to make sure that there is a proper way for them to realize what they have invested in you. Then we'll go into a little bit on corporate governance, which is a favorite topic of mine, and it applies even to the tiniest businesses. And then we'll discuss briefly exit strategies and succession planning, and then you can ask questions. All right. All right, so types of business formations. The most popular one when an idea comes to you and you see that there's a market for it is to register as a sole trader. Now, it's very useful for businesses like doctors' offices and attorneys because your professional indemnity insurance is separate. Generally, you're not really focused on a limited liability company. However, they've got more strictures because you've got to renew your registration every 3 years. You have to apply separately for your TCC, even though it uses your own personal TRN. You assume full personal liability for all your losses, successes, and you have to file an individual tax return, and you protect yourself by your own indemnity insurance. We have longed for better partnership legislation, and we now have it. So it is very important for us to discuss partnerships now, because you can actually have a limited liability partnership. So in a partnership, you've got some persons who are on the ground working day to day. Those are generally the general partners. They manage the firm, but then you have some persons who help to make the partnership work. So for example, say it was an investment company, you want to make sure that there are some limited partners who don't have power to bind the firm, and they are not going to be liable for general partner actions. So that is when you're pulling on that call for investors. You want to be able to offer them something attractive to say, look, you're not going to be burdened with any problems and the running of the firm, but why don't you come on, and here's a particular guarantee that we're going to give you, how you're going to be compensated, and this is how we want you to invest in us. This is the capital contribution we require. This is how we're going to allocate profits. This is how we're going to distribute. And when we are ready, when we think the business is mature, whether we will acquire your interest by agreement or we wind up on specific terms. If you're going to go under the new Partnership Act, and you don't have a choice because the Partnership Act is here, but when I say if you're going to go under it, I mean if you're going to make use of it, then you have to think carefully of the kind of business you have. And then sit with the partner to say, what do you want out of the business and what can I provide? This is to make sure that 5 or 4 years down into it, you don't feel like there are unmet expectations. But if you do, you would have had to have some sort of winding up or arrangement in it to prevent you from having to go to the courts to say this is how the partnership is to be dealt with. So that's why I dropped in right there, capital contributions, profit allocations, distribution, winding up. And then also you should have an indemnity clause in your partnership agreement in case anyone misbehaves. But now that it's a limited liability partnership, you can act a little bit closer to a company, which is the hallmark of business where liabilities, you can't look behind the company as to the shareholders or the owners of the company, because the law says that they are protected by that wall of limited liability. So you can get that in an informal or more formalized partnership arrangement, but you do have to make sure that you have a document that speaks to the specifics so that the court and the world can see that you're fully functional and this is not something that you guys just put together and in practice it was not, certain formalities were not complied with. So the moral of that is, don't just jump into business. When you get your business partner, you want to head to your banker, you want to head to your attorney, and you also want to head to your tax accountant to give you practical advice on the business implications and the tax implications of each company format. So I gave you a little bit more information on the Partnership Limited Act. Not, when I say not yet in force, meaning we don't have nice forms for you to fill out, like what you do when you go to the company's office to register a company, but a competent attorney can draft you a nice partnership agreement with the various suggestions that I have looked at. There is also a limited liability, limited partnership, which restricts partner liability to capital contribution. These are going to be important going forward for persons who are getting together, really with a focus on you're the person contributing the finance, as opposed to you're the person contributing the technical know-how. This will be key for entrepreneurs. Private equity investments prefer this vehicle for raising capital, where the general partner is the fund manager and the limited partner will be the investors. Now to the long-time limited liability company, which is what everybody pops down to the Office of the Registrar of Companies often to do. This is where corporate governance, which I will touch on later, comes in, because now you're not just an owner, you now have a duty to come up with a board of directors. So when you're filling out that form, says, who are my directors? It's generally for a small company, the shareholders are generally the directors. That's fine, but you still have a duty, a fiduciary duty, to act in the best interest of the company. Now, that's less important when it's very small, but when you are thinking now to attract investors, you would value your shares in that company and either decide that you're going to issue more shares or you're going to sell portions of shares. You want to now make sure that you understand your fiduciary duty to act in the best interest of the company and not just yourself. You also will have the benefit of being liable only to the extent of the company assets, but professional indemnity insurance is still recommended. The company secretary becomes more important because there should be a minute book which records everything that the company is doing. For example, say the company owns a piece of property and you're going to use that property as collateral. The company would need to meet and table the matter and pass a resolution that this is in the best interest of the company, and look at how much the monthly payments would be and agree that this is a burden or a financial burden that the company can actually take on. There have been cases that have successfully been decided on the point that the shareholders filed a derivative suit and were able to show that the company didn't have a proper meeting before certain assets were transferred or encumbered or dealt with in a particular way. So the company secretary is not something that we just check off when we're starting our company so that we can get going, but you want to consider that this is a person competent to look into the keeping and taking of minutes, the tabling of resolutions, filing annual returns, and recording changes in shareholding or ownership or even management of the company. So if a director has passed and all of that. Ownership is dictated by shareholding in a company, but we want to make sure that we know that there is a difference between a shareholder and there's a difference between a director. So shareholders don't ordinarily vote unless it's the annual general meeting or some special meeting. The management of the company is turned over to the board of directors. So ordinary shares vote, but they will have to wait for dividends to get paid. But preference shareholders won't have voting rights necessarily, but payouts are dictated by the terms of the preference share term sheet. I focus on preference shares because that's another good way to get investors into your company, even if you're not ready to go public on the market or you haven't qualified to be a publicly traded company. This is another way So you can sell ordinary shares, but you can also create a different line of shares called preference shares, where there's a specific, it's like a loan. So there's a specific time for payouts, and some of them are a little bit more tricky because they can be converted to ordinary shares if that option is there. But you want to make sure that you consider that carefully before you give somebody an option to convert their preference shares into ordinary shares, because that's when you get into what you see on television about somebody comes and says they own the company, and you're like, how do you get to own the company? Well, I mean, there was something hidden in the terms of that term sheet that allowed them to actually make certain moves that have an impact on the original allocation of ownership shares. All right, foreign companies. I'm getting a lot of questions about foreign companies, and also having situations where foreign companies own property in Jamaica, and people want to use them as collateral, and different sorts of permutations. You want to prepare yourself, if you're a foreign entity, to do business in Jamaica. And one of the ways to do that is to register a foreign branch. That's even better when you're going to the bank, because instead of starting from scratch, you can actually show the accomplishments of your foreign entity here, and accelerate your ability to deal with corporate entities. So the overseas company will simply show their compliance with the overseas regime, must register within a month of establishing their business in Jamaica, and get their own TCC. All right. Structuring business relationships between investors, active partners, silent partners. We've dealt with those three. Now I wanted to talk about work for hire. Now, the reality of it, and I practice in the area of intellectual property, the reality of it is that if you want to do everything in your business, every aspect of it, every technical function, you're likely to be burnt out. So the whole idea that you're guarding this thing that you've created, and you don't really want to bring in partners, has to go through the window. But not caution, just fear. What you want to do is plan how you're going to partner with people. On an IP level, that's great, because you want to think, am I creating something that is original? And if it is that this thing is original, how much have other persons contributed, and does their contribution amount to an ownership right? So say you you're a teacher, and you've come up with wonderful children's books, you've written them all by yourself, that is clear. But what if you approach another teacher and said, okay, would you like to work with me on the children's books? You have to contemplate, okay, the two of you are going to be the joint authors. So that is from a copyright perspective. But what about from a trademark perspective? You've got this lovely idea for a logo for your business, but you can't design using all of those technical, wonderful things that designers use, but you want to make sure that you own the logo. Not a problem hiring somebody who specializes in that area, but the documents you sign must give you the absolute right to register your logo. Also, when you're registering your logo, you want to make sure that the person who, when you're creating your logo, you want to make sure that the person that you're using is in a position to do the relevant searches to make sure that they don't spend money creating something that is substantially similar to somebody else's, and that when you're ready to do business overseas, you get hit with a cease and desist letter to say that this name belongs to someone else, or the design is substantially similar to somebody else's. So you want to focus on two aspects. You want to make sure that you're creating something that can go global, and you also want to make sure that you are able to lift and use what you've created because you're actually the owner, and that they're not some silent entanglements. Substantively now, work for hire becomes an issue when you are not in a position to finance what it is that you want to create or have the capability to create. So when you're working in a context like for a professional institution, whether they're in the business or research and development or not, you have to remember that if you are an employee, you've got to make sure that there's a contract in place that says who's going to own what, especially if the research and development is entirely funded by someone other than you. So you want to make sure that you've discussed all of that with your paying party so that there's an agreement in place. Also, when you just start your business, hiring employees full-time sometimes creates a problem, a financial problem. You want to look at the usage of independent contractors who are able to work for many persons or diverse persons. So you've got a specific contract that says, okay, you're providing this service for me, but you're not resident in my office and I'm not responsible for your taxes. So you're not doing it in a tax evasive way, but you're using what I consider a practical tool to save on unnecessary costs so that when you're ready to grow, you're saying, okay, I have got so much work here that I know I'm able to hire someone to just do this full time. That's because you actually have the work for them to perform. Not that you have some work for them to perform, but you have persons underused in your business. So that's the point about independent contractors versus employees. And we touched on intellectual property owned by the employer by default. So you have to be careful about that it's crucial for research and development relationships. Specify in your contract who owns the content. And of course, do not be afraid to negotiate. I think sometimes creative persons underestimate the value of their talent and are blindsided by the fact that, you know, they may not have the finances, but you have to think of yourself as sitting equally at the table. All right, now dictating the share of profits. If you don't remember anything else from this, remember that we must talk about the sharing of the money up front. You know, just like how, you know, when you're getting married, you know, a person might have come into the marriage with quite a bit of assets, and they also have more than one person that they're responsible for, whether children from another marriage, etc., previous marriage, adopted children, etc. And they're concerned that, wow, some of the default principles or laws, matrimonial property laws, might unfairly deal or create unfair results. So that's when they need a prenuptial agreement. You can't be afraid to talk about things like that, because that thing in the back of your mind generally comes to the surface when you're in the meat of the matter and you don't have a structure. So that is why, even though when you register your company, and I say register your company because that's the easiest one for you to look at forms that you have available now from the Office of the Registrar of Companies. Don't be confused between that articles of incorporation that you fill out that sets out who are your directors and your shareholders, and your super form that gives all the data that the company's office needs on you. There's still something else called a shareholders agreement. And in fact, sometime in the US, people, before they even register an entity, they do a founders agreement to say, okay, this is our work in progress agreement. These are the persons who are starting fresh with us. These are the terms. And of course, it will be subject to the registration of the company and etc. But you want to start with having some sort of understanding in writing, whether it's a founders agreement or a shareholders agreement, which you generally do know when you have registered the company. Now, that shareholders agreement will set out rules about profit sharing, capital contribution, and all of that beyond what you can capture in your articles of incorporation. And also remember, when you check the boxes on that first page and it says which articles you want to take and which articles you want to amend. Let me slow down here. The key articles you want to check if they're in your favor are the ones generally about succession, whether shares have to be first offered to other shareholders in the event of the demise of one shareholder. You want to think about those because it changes the ownership structure or potentially changes the ownership structure of a company. You also want to look at the rules about borrowing. You want to look at the rules about notices. And you want to look about the rules about how many directors can bind the company. And the rules about repaying loans from either directors or persons who are associated with the company. Those are some of the areas where there is potential for litigation. So you don't just want to just wholesale say, okay, let me just take articles 1 through 79. You want to see what they say because those are the model articles. And depending on the kind of business you want to do, you simply can vary some of the articles to create exactly what you need. So there is room. So you will see them, you'll see that you can check a box to say, okay, amended articles are set out in the schedule. That's the purpose of it. I think there's just too much haste sometimes when you're registering the company to get something up and running to say we have our, we have a company number, we're a registered company, but what exactly have we agreed to do and how are we going to do business? I feel like in the onset, sometimes with entrepreneurs, there's not enough emphasis on that and maybe not enough information. All right, I already touched on employees and how to manage that aspect of financial planning for the staff that you need to help you and independent contractors versus employees. Move down. All right, now you're registered. I always like to touch on the fact that you've got to remember the tax portion of it, personal tax, so income tax, corporate tax, which is your tax on profit, GCT, which is attached to the sale of goods. So that is where the accountant comes in. And corporate filings, we're back to your company secretary because you want to make sure that you understand the difference between corporate filings to the tax commissioner as opposed to corporate filings to the office of the registrar of companies. And sometimes they have the same name. For example, the annual return catches people from time to time. There's the annual return of income tax payable, the ITO2, but then there is another one, which is just a simple annual return to the registrar of companies, which is due on the anniversary of a limited liability company. And even though it's a simple form, you can be struck from the registrar for repeat non-compliance, and a daily fine is imposed for lateness in that. And the purpose behind that is that you want to make sure that companies tell you what's happening behind the scenes, because a lot can be done by virtue of resolutions. And so what's on the register may not really be the actual state of affairs in the company. So the annual return tells us that. So it's an important document. All right, now I touched on corporate governance earlier, and it's broken down generally into director conduct, remuneration of the board, because that is actually a paid position in reality, accountability to shareholders and partners. So a company should properly prepare for its annual general meeting and table the matters and also provide a proper report. But also it is ethical to make sure that you have a sustainable corporate model. And when I say sustainable corporate model, it means that you have thought about succession planning. So I've had to prepare wills where the persons are about to, or think that they can prepare a will, leaving the assets of the company to different persons. And I have to explain, no, once the asset is in the name of the company, that's not an asset that you can devise. What you should be doing is thinking about this in terms of the talents that you have. Who are you training? and how are you planning in the event that you are no longer able to carry on your business. One, documents such as a durable power of attorney. Very, very important, because you want to make sure that there's somebody who can sign, who is competent to sign. If you're unable to sign documents, bank documents, etc., business documents, you also want to make sure that you have trained someone in certain key functions to create, to prevent that sort of intellectual drain. And you also want to make sure that the key assets or the key things being used in the business belong to the business or are leased to the business. So what you don't want to happen is that the company doesn't own anything. Everything is in your name. And if you pass, now it's tied up in your estate. Whether you have left a will leaving it to a completely unrelated third party that has nothing to do with the business, or you haven't left a will at all, so that is going to go through administration. So you realize, oh, the office where we are, okay, that's now owned by somebody else. All right, the car that we're using, okay, now that's owned by someone else. All of that creates a corporate governance disaster in the event of your passing. And we have lots to look at when trying to draft a corporate governance code for your business, because every business should have some sort of, whether it's a detailed code, depending on how many employees and the scope and scale of your business. So you have many options to look at. Jamaica Corporate Governance Code, the Private Sector Organization of Jamaica Corporate Governance Code. And when you look at some of these codes, they talk about that the family, so it's a family business, the family should come up with a procedure in the event that the matriarch or the patriarch passes or is unable to work, who's the person that is being trained, etc. All right. What if things fall apart? I discussed before the value of the shareholders agreement separate from the articles of incorporation. And that's not something you're going to get from the company's office. That's something that you're going to have to sit with somebody competent in that, whether you're a business advisor or an attorney. You want to note that the more complicated business closure is perhaps the limited liability company, because there is a winding up process where there are assets and liabilities that require you to pretty much work through a system of identifying creditors and taking formal steps, as opposed to removal by request of the registrar, because the company has no assets and has ceased operation. And of course, the Bankruptcy and Insolvency Act of 2014 allows business to obtain protection from creditors as they rebuild if you're having a genuine problem. And that has become increasingly important post-COVID, especially for smaller entities. And now over to you if you have any questions. And this is where I am, the Law Office of Cavelle Johnston at 6 Eastern Avenue, and my contact is below.
Thank you, Cavelle. All right. So do you have any questions, anyone?
Let me look if there are questions in the chat.
No, I don't see any questions in the chat, but I knew some persons had raised their hand.
Oh, let's see. Okay, so there were some hands raised. So I'm happy now we're taking those questions, because I wasn't looking at that aspect of the top of the screen.
Hello, good afternoon. You hear me?
Yes, hearing you.
What about the international copyright and international trademark? When do you get the global also too?
Right. Okay, that's a very good question. We know there's always been the Jamaica Intellectual Property Office, and they have been lobbying for us to really join some of the key protocols that will assist with international registration. So we have now, in relation to trademarks, joined and signed on onto the Madrid Protocol, which allows for one application, and for you to specifically indicate where you want to be registered. And you can be registered in more than one place. Similarly, there has been a great overhaul of the whole old patent legislation, and combined into a great new system that puts together the whole system of design. So, you know, you have designs like shoe designs and handbag designs versus a patent, which is an invention, which is, you know, something novel, which you have to go through various strictures and disclose exactly what procedures you did to create this thing. And then, of course, you would get an exclusive period where nobody can use this thing without your permission. So that is a great system if you've got, that covers the main areas. I'm gonna leave copyright for now. I'm going to focus on so that trail of trademark, which means what it means, a mark to be used in the trade, and a patent, which is this invention, you've got something novel, and a design, which is whether it is it's a tangible expression of some kind of graphical or drawing or something with texture. That covers quite a bit of what a manufacturer or a developer would be doing. If you are now on the side of a trade secret, that is not something you register, that is something that you take steps through a confidentiality agreement to keep secret. So that's like a recipe, like a commercial recipe that you would want to disclose it for the purpose of testing, and obviously you have to do your ingredients and the portion and percentage and fat and etc. blah. But the actual how we put it together, what people loosely call the sauce, is a trade secret. The world of source code and copyright, because a lot of people are asking questions about graphical matters. The rules are separate, are a little different in terms of what is covered on the copyright versus what is covered under trademark. So you'll find that if you're going to do a computer program, you're probably going to be looking to copyright protection. So you want to be sitting with a seasoned attorney to say to you, okay, where do you want to register? First registration becomes important. Where do you want to register your product to get the best intellectual property protection? So that is not something that you just leave up in the air. That is something that you visit Jaipur, get information, speak with an IP counsel and take that from there. So the point of, I'm giving a long answer to your question, but I want you to take away from that when you have something and you register it locally under the various schemes we have here, there are now opportunities for you to do more than that, to seek registration in international markets. So you want to have that on your agenda as well.
We have some.
So there is supposed to be a specific international trademark or copyright office where it's recognized in all countries.
Right, so we're talking about the same thing. You're giving a very good description of what it does, but I'm saying that you have to approach that through your local intellectual property office still, but you can place an indication that you want to be registered internationally and different fees apply, but you would do one application, even though it is going to result in an international registration. So you're not advised to bypass your local IP office. If you are situated overseas, then that is different. But I'm saying that if you're located in Jamaica the fact that there is an international, and when I say international, I say quote unquote, there is an opportunity for you to test the ability to register your mark in a foreign country, which is very important if you intend to distribute. So say you are making, teas, and you're making some special containers to hold the teas, and you have a distinct label. So you've got several potential types of intellectual property. You want to make sure that you have consulted with an attorney to say, okay, when I get to Canada, when I ship these things, when I export them, somebody in Canada can't just look at my tea and say, wow, but I could make this in Canada and I can use the same name and people are going to think it's the Canadian tea. They're going to think it's a Jamaican tea. You want to make sure that your trademark is protected, that you have protected the formula for the product, and that your trade dress, the unique marking of how you have put together your packaging, is protected by intellectual property. That's the purpose. That's one of the main purposes of seeking international registration, because if you're only registered in Jamaica and you're not registered in other foreign countries where you are actively doing business, then when somebody tries to palm or pass off your work, you have very little recourse except for the common law, exactly what I'm calling it. You've got a common law claim, but you don't have the greater protection that you can get in the particular territory. So I don't want you to take away that there is this international copyright, but rather that there is an international system of registration where you can register your intellectual property in more than one jurisdiction. Because as it is, without that, you have to register your mark in the US, you have to register your mark in Jamaica, you have to register your mark in the UK, because one registration without more doesn't give you protection in a different jurisdiction.
Hi, Ms. Johnston. Great presentation. So I have a question about the limited liability partnership. I'm not aware of an option at the company's office where you can register as such. Is it that you would have that set up in your internal partnership agreement?
Right. So that's what I was saying earlier, that unlike the this well-oiled machinery you have when you're going to register a limited liability company, you have your super form, and you have your articles of incorporation, and you have an idea of what schedules you're going to take wholeheartedly and the others that you think you want to doctor. You don't have those forms yet when it comes to the limited liability partnership. And let me see if I can move back in the slide. So what you have to do now is look to jurisdictions like Canada and the UK and kind of prepare something that your client understands and that everybody can be bound by. So I'm now back in that portion of the slide. Let me check something. Good. So what makes a difference is that you have a partnership act. Generally, partners, even before this fancy legislation, would just come together and do a partnership agreement. And generally, once the death of one partner, there is a general, automatically the partnership dissolves. And the partners and the remaining partners start a new partnership and proceed. And of course, there is, unless there's an exclusion clause, you're generally responsible for the mistakes of your partner. And so if your partner is bankrupt, boy, you are potentially in trouble, or there's misconduct with clients' funds or resources. Now that we have this new Limited Liability Partnership Act, what you can now do with using your own drafting skills is to draft an agreement that captures limited liability for partners, but it's not just any partners. There are rules about it. So the general partners who are responsible for the day-to-day running are treated separately from the silent partners who can show that what they did was just give some sort of capital input, etc. But there are good aspects to this legislation in that we now have a good vehicle for pushing business in Jamaica, because investors can now say, okay, I am going to opt to be a limited liability partner, in that I'm not interested in voting, I'm just interested in my return. So I'm going to put in this amount of money. This is the return that I am to get. And I'm not responsible for your for any mistakes you've made, but also I cannot bind the company. So I can't be the entity. So I can't be issuing letters on a letterhead, etc., going to the bank, all of that stuff. That is for the general partner. So the key takeaway from that is that it's something you're going to have to draft. But if you want some guidance, you can just check some of the countries that have had those kind of legislation long before, because it will allow you to draft a little faster. And of course, the key things that clauses that you'll be drafting around would have to be capital contributions, profit allocations, how much and when, same thing, distribution, and winding up what happens if one partner dies, and how you don't want a complicated system, but you want a system that allows for business continuity.
Okay, so is it that until the act is in full force, you will have to draft that agreement?
You have to draft, yeah, but okay. you can get some guidance, because remember, our Companies Act looked closely to the Canadian system. So I don't know what they will look to in terms of, the production of the forms when they get to it. Mm-hmm. But you can safely say, when you're looking at those kind of precedents, you are in the right. Of course, I know you're going to read the legislation itself, which mm-hmm. tells you what you can and cannot do. But in terms of the drafting, you can be assisted by that.
Okay, thank you.
Okay, so we have some other questions here.
Go ahead.
How does the work for hire agreement differ from that of an independent contractor?
Excellent question. So an independent contractor is simply one that comes into your entity with a specific purpose, to provide a specific purpose. When I say for a specific purpose, or to provide a specific service, it means that you've basically said, I need a graphic artist. May not need a graphic artist full-time, but I need one. Or I need an accountant, but I don't need an accountant full-time. I don't even need an accountant part-time. I simply need an accounting services. I simply need bureau services. That's what it is. But your secretary in office full-time is completely separate, unless it is that you are using the services of a company or an entity that provides corporate secretarial services, meaning I'm having a board meeting and I need these things done. So I'm asking you to work for 2 days preparing the documents for the board meeting. That person is an independent contractor. So it is exactly what you've tasked them to, for how long, when, and for what remuneration. But the great work for hire is saying, I have got a specific thing that I want to be created. But at the end of the day, whatever you have done is going to be owned by me. If it is that the parties negotiate something different, that's okay. But the default is that if I bring you into my office and I say, design my office logo, you're not going to walk away owning the office logo, because this was something you were hired to do. So there can be overlap in that this independent contractor can fall under a work for hire situation depending on the tools that were provided. And that is why I said that if somebody is not coming into your office and you have remotely hired them to create your IP, you've got to make sure that they are not, or they have signed a waiver to say that this is owned by you because they're the creator. You didn't give them, you paid them for their time, but you didn't give them the tools or do any sort of material supervision that would say you have some sort of creative input. So they set it so that the two can overlap, but the function is different. The crucial work for hire track is when you've got something that you want created. You've got a mind that can create it, but you want to be able to determine who is going to own it. Now, the default, if nothing is in place, then the person who has created this thing would own it. But if there's a proper agreement, there would be a separation of the various types of rights. Moral rights would be something that, you know, are, even if there's a contract that says, I am not going to be the owner, the fact that I'm the creator, I still have moral rights to prevent it from being used in a disparaging way, a way that would actually hurt my ethos or hurt my future business, to see something that has been associated with me, whether highly publicly or not, being used in a particular way. So those are, you could almost call them unalienable rights. But in terms of who would be able to register the trademark or register the copyright, that is something that would be controlled by the work for hire agreement. But an independent contractor is to be juxtaposed against an employee, meaning an employee, you're going to be responsible for their taxes and statutory deductions, etc. But the independent contractor is just as if you said you looked in the yellow pages and hired somebody for a specific service. They don't even have to come into your office. They don't have to use any of your tools. You just say, you know what, I want these programs for this business event designed, and the person produces them. Does that help you?
I am assuming that helped. Shanice Jones.
Hi, good day, everyone. I had a question as it relates to partnerships. Is it illegal if, say, one partner removes another without their knowledge? Same goes with the limited liability. If you're removing a director, they don't necessarily have to sign. But is it, you know, is there a legal way to go about it?
So let me deal with the limited liability company first. So a director can be removed for cause, but the case law and the Companies Act normally requires that this is something that is voted upon. And in fact, everyone would have to know that what we're tabling here is a determination as to whether John Brown is to be removed for cause. That said, shareholders get to decide on who will be their directors post the initial directors that started the company. So actually, a director can actually be removed. So to answer your question, if there's a proper resolution removing the director does not need to sign. Simply, there is a form that is filed at the company's office to indicate that through whatever mechanism, this director is being removed. When it comes to the partnership, it's a little bit different in that the partnership agreement governs. So there is no directors in a partnership. Let's make that clear. There are only general partners and limited partners. And so for the removal of a partner from the actual partnership, it would have to be done in accordance with the partnership agreement. And generally, a partnership agreement doesn't speak to removal of a partner, but that indicates that certain conduct would actually trigger, like you are not going to be liable for what you have done, say you have stolen money, etc., and dictate some terms that would trigger a winding up of the partnership so that it can be declared that we're not responsible for you and we're going to go our separate ways. And the partnership will continue whether, under the same name or how the names are to be dealt with. All of that will be specified.
All right.
Okay, understood. Thanks.
Okay, so we have some other questions here. Can someone start a limited liability company if they are not yet up to date with their personal taxes?
Their personal taxes. All right, so there is no requirement. Let's just look at it from two aspects. So when you're starting a limited liability company, you're required to disclose your address, TRN, other directorships that you have, depending on the kind of company that is being formed. But, so other directorship posts you're holding, but that is generally if your occupation is a director, meaning that you don't have another substantive job. So your personal finances, that's not applicable. Your issue will be if you're a sole trader, because you have to apply for your own TCC, because a company gets a TCC automatically when you register your company. But if you are a sole trader, you need to apply for your own TCs, and your status with your taxes will create a problem. If that is not clear, then you can't get your TCC.
Okay. So we're also, Danielle, she's saying that she's a HR consultant, but she wanted to know if she should be able to be a limited liability or remain as a sole trader.
Oh, that's a good question, because it means that she's considering that, okay, I started out as a sole trader, but do I need do I need a different business model, right? If the business model you have actually allows you to interface with all your business partners, meaning your banks, your accountant, in a way that works for you, then it's probably not an issue that, okay, I have to jump now and join a partnership. When you're looking for a partner to join, or when you're looking to create a partnership, it is generally because it's a means to add a business skill, meaning there's somebody you want to come into the business to provide a particular service that you were hitherto unable to offer, or you're going to offer it better with the person, or it's an investor. So it's a necessity. So meaning if you're going to really work with partners, then you probably want to think of at least a basic partnership agreement that speaks to what I discussed, which is the capital contributions, how we're going to deal with profit, and how we're going to move on if we don't work well, and also clearly how we're going to indemnify others, because to the world we are one. When you write, Johnston and Brown partnership, if you can't find Mr. Brown, you're going to go to Johnston. So you want to make sure that you have a document and a business practice that supports the outcome you need. So if the persons you are working with are employers in the standard form, meaning they're not business partners in the creative or the financial aspect of it, then there really is no need to move unless you are concerned about limited liability. That would really be it. That's the fact that if somebody were to sue you, you would be exposed.
Okay, and so if they were to hire employees, would it be better for them to be limited liability?
Anybody can hire employees, but the key thing is to look at your potential exposure. So if you're thinking that, well, aside from my professional indemnity insurance, boy, I could actually be hit with some sort of lawsuit or some sort of issue that could wipe out not only the business but wipe me out, then that's one of the key considerations for limited liability, whether it's a limited liability company or a partnership. You want to think about your exposure. An example I heard of was a foreign company was in the business of making cheese. And it was discovered that somebody ate from a batch of cheese that was contaminated, and the lawsuit pretty much tanked the company because there was a fatality, meaning the person, whatever they picked up, the kind of bacteria, they died from it. And I'm not sure if it was even more than one. That wiped out the company. But at the very least, it had to stop at the company. Just picture if, say, they were insured 45 million US, but they got the jury awarded 200,000 thinking that 200,000 US thinking that this was particularly gross, how they, how their business, their health practices, etc. They would have eaten through their professional indemnity insurance because there was a cap. They would have eaten through all the business assets. But now, if you're not a limited liability entity, they can now come to you. But under the corporate legislation, once you're a limited liability, whether it's a partnership or a company, wherever the entity stops in terms of assets and professional indemnity, that's where it stops for you.
Okay, we have a question here. If I have an HR business in Jamaica, but do consulting for companies in other islands, what is the best way to do this? Should I start a new company in the new island, or can the one in Jamaica work in the other islands? How can I avoid taxes in this regard?
Okay. Part of that question is, when you say avoid taxes, I don't generally like that word. What I like is, how can I plan for taxation in a way that is fair to my company? Because immediately you're thinking about double taxation. You're also thinking about whether GCT would apply and how it would apply. For example, your accountant will tell you that if the good is not produced in Jamaica, generally GCT would not apply, but there are rules about it. So you talk with your tax accountant to say, actually, it's a saving for me to have a foreign branch, because it's people I want to use to make the thing, or put together the handbags or put together whatever the product, are actually well suited in that entity. And then your accountant will say, but actually this is the best way to go, especially in how you are constructing your business so that you're not unfairly taxed. So I like to look at it in a broad way to say taxation should really reflect what is really happening in the business. But sometimes if you don't have a good knowledge of tax law, you end up, the way how your business is framed and presented not in a sustainable way. You're actually going to die, because the way how you are being taxed over there and you're being taxed here, you really, and by the time you pay all the deductions for staff all over, because if you have a company registered in a particular jurisdiction, you're going to have to abide by their laws. So the formula for resolving that, which is not just a yes or no kind of thing in a context, like you just ask a question and we know it. What I want to do is give you the skills to determine. Your tax accountant now would be fluid in what is happening in Jamaica in terms of taxes and shelters, and what's happening in the jurisdiction where you are producing or you're thinking you're located, right? And the short answer may be, you may do a foreign branch, or you may register a local entity there, because you're familiar with their taxation system and you have looked at the GCT system here. Because most countries have some sort of value added tax, VAT, whether they call it GCT or not. And the purpose of value added taxes is to ensure that there are some across the board taxes that just hit basically everyone except for the excluded items. So that you remember when GCT came about, one of the big discussions was there are some people who are just outside the tax net for whatever reason or another. And so the so-called tax burden is on a so-called registered few. You want to ensure that you are looking at it from the perspective of the reality of your business and sustaining the business rather than just saying that you want to avoid taxes. And you also want to have a combination of discussions between your attorney and your accountant before you decide where you want to be, because you might find that you're in this foreign country, but you don't understand the rules. So you're coming up against financial constraints that you did not plan for in your business plan.
Okay, Earl, you had a question?
Yes. So I heard your touch point on independent contractors earlier. My question goes towards independent contractors, right? So having a limited liability company, is there a disadvantage of hiring independent contractor on a full-time contractual basis?
Very good question, right? So that recent case with the security companies, I've actually looked closely at the judgment. You remember there was an issue as to whether certain statutories should have been paid for the staff of the security company, and certain facts that were hitherto, indicative of an independent contractor. The court was saying, but in reality, they're your employee. A good example of that is where people are uniformed and deployed, and there is a kind of automatic rehiring. So even if you have a formality that says, oh, this is a 6-month contract, it's not a 6-month contract where, okay, well, I'll see you 6 months later. So you're working 6 months out of the year. It's a formality where we all come to the office and we just sign new contracts. What the court is looking at is protecting employees from systems that affect their abilities to participate in schemes designed to assist with retirement and housing and those kinds of emoluments. So when you look at your question, should you or should you not hire independent contractors? You have to think, what is the need you have for it? Because you don't want to waste your money paying taxes and taking, having to do all these deductions for staff that is not, their services are not required full-time. It would be like me, solar practitioner, hire a full-time bureau. You don't need a full-time bureau. So your business plan that doesn't accord with it, what you need is somebody that you can call and say, I have a package to be sent up to Hope Road. So what you need is bearer services, and the person sends you an invoice and you pay it. They can go and work for 10, 11 attorneys. All they do is organize their time to say, okay, this is when I'm going downtown, and everybody who has something downtown, you give him something and he takes it downtown. So what I want to focus on is that every business should have a business plan. So on the business plan, we know how many people we need and what they should be doing and how many hours of work it will take in the onset to accomplish this job you have done in a sustainable thing that halfway through the year, you're not running to the bank to say, I don't have any operational cash. That is where your mind should be. It's not avoiding this and that. It's really, how should it work to my best advantage? So if it is that I really need a full-time employee, ethically, you shouldn't contrive to say, we're gonna just do it a particular way to make it appear that, because what you're doing, you may be okay, but then you're opening yourself for litigation and having to pay money in the rear when a court of law determines that what you were doing was actually it actually contravened the law. That's it. People are responsible for what they sign. So a contract generally is governed by its terms. It's just that employment contracts, they have certain legislation. So your personal agreement is not final because you've got several pieces of legislation that govern how employees are to be treated, you know, from holidays with pay act to employment termination and redundancy, to the fact that if you want to fire somebody, you have to have a hearing and give them the opportunity to respond, etc. So that is, if you have started a business, you want to have a business plan that determines how much money can you spend on employees and really whether you can afford to just have part-time, because you know if you have part-time, once they're past the statutory threshold, you know the same sort of employment requirements will kick in. I'm talking about the 1.5, the tax threshold, and of course the various statutory deductions continue to apply. So part-time is not a miracle cure for anything. Really, it's between independent contractor and employee and employee of the entity. And it will be determined by the reality of what kind of work do they perform, how do they perform it, are they on site, by a number of factors to see whether or not is they're real independent contractors, or you're just masking full-time workers, sorry, you're masking employees as contractors.
All right, so we're gonna take two more questions, one from Shanice and then from Tarazi, and then we're going to end, okay? All right, so Sharice? She's gone. All right, Tarazi? Or Taraz?
Therese, thank you so very much for taking my question. So it is in regards to the independent contractor. What I wanted to find out, so for example, a business model that would definitely require an independent contractor, say the projects that are being worked on, the clients that we're serving. Well, let me just give you a bit of snap. So I have what you would call like a freelancing business as a freelancer myself, right? So I contract other freelancers, other independent contractors to assist with the workload. Now the clients can say, hey, we want you to work for us. No time is specified. So they have some work and you would do the work indefinitely, right? With an agreed payment of say weekly or fortnightly or whatever. No, the time can say to you today that, as of tomorrow we'll discontinue your services, or as of immediately, we no longer need your services, right? So in that case, then I would have to advise the persons who are assisting me. So those other freelancers, like, hey, as of tomorrow, we will no longer be
right. So there's a feedback. So before you ask your question, I want to make sure I'm following you. Because of the feedback, I was having a little trouble. I don't want to get to the question or not. Yes, so let me see if I understand what you're saying. You're saying you provide a service, but to get the service done, you need other persons to help you.
Yes.
And you're needing their help is based on whether you've got a client who has come up with a payment, who has come up with a payment proposal, or just going to pay you outright, meaning, or depending on how you have provided your service, meaning you have to pay a 50% deposit and then you pay at the end, whatever. But it seems to me that where you left off was you have a client that can actually tell you that they don't need your services, and you're wondering what would you do with the people that you have put to work?
Or better yet, well, you're very much on the right path in what I'm asking. So what I want to find out, I give them independent contractual agreement, which basically states that, you know, you would work. So you would work based on the needs of the business. So I would contact them if I need their services. So the independent agreement would state that, hey, you provide this service to me. It's also a non-disclosure agreement, but me needing their service is dependent on the needs of my client. So I may have clients who require the service ongoing, no specific end time in mind. They will call and they'll say, hey, it's this week we will no longer need the service, or Christmas is coming, we'll break for a month, or we'll break for a week, or we don't want you tomorrow. You know, so I would hire, or not hire, sorry, let me correct that. I would contract other freelancers to assist me accordingly. So
Right.
we may have somebody working for 6 months, or let's say even up to a year, every day at a set time, but they are freelancers. How would I arrange an independent contractor agreement to facilitate that, knowing that they may be working with me straight for 6 months or straight for a year?
Right. So an independent contractor is just an allocation of the burden of taxation and reporting and deductions. So it doesn't mean it's not going to be done. It's just not going to be done by you. So I don't want you to be perplexed by the duration of the contract. And just to be clear, I focused on that earlier in saying that when you make artificial arrangements, the court will look behind them. But if the practical reality of the kind of work means that it may be for a long period, but it may not be for a long period, that is irrelevant. It is the structure of the agreement. The structure of it is that you require assistance to produce work upon request, meaning you are not hiring these persons full-time as your employee, because if there is no work, if you don't get a contract,
Yes.
there's no work for them to do. That is a decent basis. And there may be other considerations. That is a decent basis for the finding of a genuine independent contractor relationship. Meaning, say you're a you're a wedding planner and decorator. When you keep a team, or you have a network of persons that you say, oh my gosh, I have 5 weddings, so I need some help. And those persons know you generally get work, so they have an idea, they work for you and they work for other persons. Think of it in that context, that you never get past the real reason for the relationship. So it has to be a relationship like that, because it is only upon request. You're not providing, you're not housing them in your office. They work remotely. They're free to work for anybody. You don't determine their other business. You just give them a task and say, prepare 10 white table settings for this wedding. That is what the task that you're assigning them to do, and they state a fee. So you have not hired them to say, come into my office and you're going to be the resident person who deals with this for me. If that is so, then they're an employee. Whether or not you give them a contract, nobody cares, because you are controlling their work.
Because for me, all of them work remotely. And I have clients who have, there's no time frame set. At the end of the day, I say.
So you are correct. I think you're perplexed by, well, I'm not going to say what you're perplexed by, but I'm saying the issues that have arisen with other staff is really because the staff is uniformed, full-time, can't control what they're doing, can't control where they're placed, the whole 9 yards, yet you say they're independent contractors. But do not confuse seasonal work upon request.
Oh.
Yeah, 2 different things.
All right, I think that we have talked Cavelle out. Right, so today was meant to be a webinar on legal matters affecting SMEs, and Cavelle, you did an awesome job. And then please be reminded that this is not legal advice that we are providing for you. And if you want to seek advice from counsel, do so from the law offices of Cavelle Johnston, right?
Just one more thing before we go. I just looked in the chat and realized persons had a lot of questions about what is a professional indemnity plan.
Yes.
So, so there are companies, just like you think of car insurance, the whole idea of insurance is to protect whatever you have at risk. So if you're a business professional, you want to ensure that, okay, if there's some disaster that has affected your office, your storehouse, or your staff, you've got a sum of money that you can pull on to come back and be made whole. Or if there's an accident or something on site, meaning not a motor vehicle accident, because generally, you know, that's covered under, you're required to have motor vehicle insurance. You want to make sure that you've got something that can respond. A good example of that, or a bad example of that, is that you've got you have employees and they go to install something. So you're in the business of installing awnings and somebody falls off the ladder. Now the person who hired it to put their awning up is not liable unless there was something weird in their pavement that you wouldn't have known and it caused some sort of injury. Generally, if it's some mistake that he made and miscalculated and he falls off, he's injured on the job. And then there will be a question as to whether or not he was acting prudently and all of that. You want to make sure that in the event of all of that, nobody is coming to knock on your door and you are now going to pull funds from the assets of the business or the working capital of the business. So that's the whole concept of professional indemnity. You can get it for just about anything that you're doing, whether it is medical, legal, accounting, the service industry, etc. So what you want to do is just stop by any insurance company that you have a relationship with or not, and just start asking about general indemnity insurance, and they'll go into different types like peril, professional liability, and you can get a quote. So anybody can get a quote to answer that question. Sole traders can get indemnity insurance, just about anybody. All right.
All right, Cavelle, can you show us your contact page again at the ending?
All right.
And so if there's anyone that wants to get in contact with Cavelle, because this is the second time that we've done a webinar with Cavelle, and she always has lots and lots of questions being answered. And so we decided to give her her own platform and have her do one webinar. But as you can see, if I had sat down and read out your bio, that would at least take three minutes of the time. Cavelle is very, very knowledgeable. She knows a lot. She's in everything like salt, which, yes, she's on this board, that board, and that board, right? Everyone's always seeking out some advice from Cavelle. So if y'all want to do that as well, you can do so. Her information is on the screen. All right, so thank you all for joining us. And thank you so much again, Cavelle, for coming on and doing this. And it's being recorded, and what we're going to do is send you a copy of the recording. All right, so we will, and we also have some webinars coming up. The workshop coming up. So you can also look forward to seeing information on our Instagram pages as well as our social media pages. All right.
Excellent. So thank you for having me. You're really kind of just making me like, oh boy, I'm a grown-up. I don't know all about that big introduction, but thank you so much. And I'm happy that I was able to answer some questions and kind of give some guidance that, these are the kind of things to be thinking about, knowing that one size doesn't fit all. You have to remember that. And you always want to engage the professionals when you're actually doing work. Don't substitute this for legal advice.
Exactly, exactly. All right. Thank you all for joining us, and we're going to end now.